Good evening to the participants of the JCJ 2022. The exam is going to be held on 26th November 2022 if there is no postman is there. Participants, anyone can unmute and read what I posted on the screen.
Welcome to the participant of JCJ 2022-ME main examination 21-11-2022. Various types of appeal under CPC Civil Procedure Code. Appeal from original decree section 96, 97, 98, 99 and 99 capital A order 41 CPC. Appeals from appellant decree section 100 capital A 101, 102, 103 and order 42 CPC. Appeals from orders section 104, 105, 106 and order 43. Appeals to Supreme Court under section 109, 112 and order 45. Appeal by an indigent person, order 44. Appeal power to appellate court, section 107. Professor Dr. Mohammed Saheb Hussain, Professor of Law, SWAT, Tanzania, East Africa.
Very good, very good. Now let us go to the point of our study is concerned. We covered the asterisk mark in our last class. Continuity from there. One right to appeal. I repeat, one right to appeal. Section 96 of the CPC provides that an aggrieved party to any decree which was passed by the court while exercising its original jurisdiction is conferred with at least one right to appeal to a higher authority designated for this purpose, unless the provisions of any statute make an exception for it. Section 97, 98 and 102 of the CPC enumerate certain conditions under which no further appeal is permitted, hence attributing to a single right of appeal. Does it mean that every person having a right for one appeal? Number one. Number two, is there anything under 97, 98, 102 of the CPC enumerates the condition under which no further appeal is permitted, hence attributing to a single right of appeal? That means after availing the one appeal, no further appeal, does it mean?
1 minute, sir. Let me see this thing. CPC. One second, sir. CPC, where is my CPC book? 1 second.
Based on one right to appeal.
CPC Bear Act.
See the section 96, one appeal is allowed.
Yes, sir.
When your matter comes to the 97, 98, 102, there is a certain condition under which no further appeal is permitted, hence attributing to a single right of appeal. If once the single right of appeal is over, no further appeal could be made. That is the reason they said one attributing to a single right of appeal. Now let's see the no right to appeal, what they say, so that we can get an idea. When you go to the point of no right to appeal, no person has a right to appeal against a decision unless he is a party to the suit, okay, except on a special leave of the court. An essential element to be taken into account while considering one's right to appeal is whether such a person is adversely affected by the decision or suit, which is a question of fact to be determined in each case. So, once the appeal is made, and that to be appeal could be made by a person who is party to the suit, except for the special leave of the court. An essential element to be taken into account while considering one's right to appeal, the essential element, whether such a person is adversely affected by the decision or the suit. Naturally, when a person is adversely affected or when he is aggrieved, when he is not satisfied by the lower court decision, then he is having a right to appeal, and which is a question of fact to be determined in each case. Could the court will strictly say that there is no further appeal?
No, it's not like that. But there are situations where you can't go in appeal. There are some cases like that.
So determine each case. It is depend upon the merits of the case.
Yes, merits of the case.
Now let us see the Garikapati Viraya versus Subbaya Chowdhury. In the instant case, it was held that the pre-existing right to appeal to the federal court continued to exist, and the old law which created such a right also continued to exist. It constituted to the preservation of this right while recognizing the change in its judicial machinery from the federal court to the Supreme Court. However, the continuation of the old law is subject to the provision of the Constitution. If the old law is repealed completely, when the case is pending and the case is running with the old law, I am sure that old law holds good. Am I right?
Yes.
Provided the old law is not contrary to the Constitution.
Yeah.
That is to say, the old law is subject to the provision of the Constitution. Now let us see the first appeal. Section 96 of the CPC provides that an appeal shall lie from a decree passed by any court exercising original jurisdiction to the authorized appellate court, except where expressly prohibited. If it is expressly prohibited over there, depending upon the nature of the case is concerned, then no appeal could be made. A combined reading of the section 2, subsection 2, 2, 9 and 96 of the CPC indicates that a regular first appeal may or may not be maintainable against such an adjudication. So they say may or may not be a maintainable against certain adjudication, means first appeal. Who may appeal? A regular first appeal may be preferred by one of the following. 1. Any party to the suit adversely affected by a decree, or if such a party is dead, by his legal representatives under section 146. Second, a transferee of the interest of such a party, who so far as such interest is concerned, is bound by the decree, provided his name is entered on the record of the suit. Okay. An action purchaser may appeal against an order in execution setting aside the sale on the ground of fraud. So an action purchaser may appeal against an order in setting aside the sale on the ground of fraud. Of course, the fraud is made over there at the time purchaser may appeal it. No other person, unless he is a party to the suit, is entitled to appeal under section 96. Means party to the suit is having a right to appeal. If the party died, then the representative may appeal, may continue.
Yes.
A person who is not a party to a suit may prefer an appeal from a decree, order, if he is bound, aggrieved, or prejudicially affected by it via special leave of the appellate court. I repeat, a person who is not a party to the suit, may prefer an appeal from a decree or order if he is bound or aggrieved or prejudicially affected by it via special leave of the appellate court. That means if he is suffered over there, can the appellate court will not entertain such a case? Answer is definitely a person who agreed will approach to the appellate court. By special
Yes.
Then appeal by one plaintiff against another plaintiff. In Iftikhar Ahmed versus Syed Meherban Ali, it concurred that if there exists a conflict of interest between the plaintiffs and it is necessary to resolve it via the court to relieve the defendant, if it is in fact decided, it will operate on the lines of the res judicata between the co-plaintiff in the subsequent suit. That means appeal by one plaintiff against another plaintiff cannot be made because the case is already decided. Then the res judicata will apply to the co-plaintiff also in the subsequent suit. Because he cannot go for the subsequent suit because the case is already decided. The same result will be applicable, same order would be applicable, or decree would be applicable, or judgment would be applicable. Appeal by one defendant against another defendant. The rule in a case where an appeal is preferred not against the originally opposite party but against a co-defendant on a question of law, it could be allowed. Such an appeal would lie even against a finding if it is necessary while operating as a res judicata. That is a matter that has been adjudicated by the competent court and hence may not be pursued further by the same parties. If the matter is settled over there, then the co-defendant cannot go for the appeal because the matter is already settled. And who cannot appeal? A party who waives his or her right to prefer an appeal against a judgment cannot file it at a later stage. Further, as inferred from the Scruton LJ's words, it startles me that a person can say the judgment is wrong and at the same time accept the payment under the judgment as being right. In my opinion, you cannot take the benefit judgment as being the good and then appeal against it as being a bad. So take whole as it is. Either you accept it or you reject it. Is it not?
You reject it. Yes, yes.
The good one you accept it, the bad one you reject, you cannot. Either you accept totally or you reject totally. If a party ratifies any decision of the court by accepting and acknowledging the provisions under it, it may be stopped from the appealing the judgment in a higher forum. Means law of estoppel will work over there or operate over there. Because once he accepted and acknowledged.
And even when a person does compromise,
yes,
he cannot go for appeal next time.
Yeah, and even waives his right.
Yeah, he waives his right.
So the appeal against the ex parte decree. In the first appeal under section 96 class 2 subsection 2, the defendant on the merits of the suit can contend that the material brought on record by the plaintiff were insufficient for passing a decree in his favor or that the suit was not otherwise maintainable. Alternatively, an application may be presented to set aside such an ex parte decree. It is a decree passed against the defendant in absentia. Both of these remedies are concurrent in nature. Moreover, in an appeal against an ex parte decree, the appellate court is competent to go into the question of the proprietary or otherwise of an ex parte decree passed by the trial court. As we read it, at any stage of the case, one can amend the plaint or a new idea can be brought, a new evidence will be brought over there.
A new party can also be added or deleted.
One more, another party can be also added. Can you say rejoinder?
Yes, rejoined. Let's presume I've added 3 people.
Okay.
But I forgot that one other person, but later on I've come to know this person also was involved in this. So I can add that person under Order 1, Rule 10.
Okay. But can't you give the notice to the other party?
Yes, we have to send notice.
Okay.
Order 1, Rule 10 says, or else if I come to know that while filing, I'll file against 3 people, but later on I'll come to know only 2 people name should be there. I can also delete one party name.
Could the court will punish you and fine you?
No. This because I've come to know later on that this person name should not be included, but I've included. Now I'm deleting it.
Okay.
Okay.
So no
There is a
appeal
provision
against.
in law.
Yeah. So it can, a parties can be eliminated, a parties can be added
Yes, yes.
before the disposal of the case.
Yes, even
Suit.
during a trial, I'll tell you it. Order
Okay.
1, Rule 10.
Okay. No appeal against the consent decree. Section 96(3), based on the broad principle of estoppel, declares that no decree passed by the consent of the party shall be appealable. However, an appeal lies against the consent decree where the ground of attack is that consent decree is unlawful, being in contravention with the statute that the council had no authority. So when the consent is given, if it is found that it is unlawful or it is a contravention of the statute would be there, then such a consent of the parties will not be taken into consideration. Is it not?
Yes.
If it is not such a case, then the principle of estoppel will be applicable there. No appeal in petty cases. Section 96(4) bars appeal except on point of law in cases where the value of the subject matter of the original suit does not exceed 10,000, as cognizable by the court of small causes. The underlying objective of this provision is to reduce the number of the appeals in petty cases. Okay. Because for petty cases, again, if the appeal would be allowed, then naturally there is a multiplication of the cases.
There is no end to that.
Yeah, that's why you can say trivial matters, there is no appeal.
Yes.
Trifles will say, TRIFLE, trifles. The appeal against the preliminary decree. Section 97 provides that the failure to appeal against a preliminary decree is a bar to raising any objection to it in the appeal against a final decree. The court in the case of the Subbanna versus Subbanna provides that the object of the section is that questions which have been urged by the parties and decided by the court at the stage of the preliminary decree will not be open for re-agitation at the stage of preparation of the final decree. It would be considered as a finally decided if no appeal is preferred against it. Because when the preliminary decree is given over there, again it cannot be changed. When their final decree is going to be given by the court. So it will be considered as a finally decided. But if no appeal is preferred against it, if the appeal is not preferred over it, then the final decree is the last decree and it is a binding one. Am I right? If no appeal is preferred against the final decree. No appeal against a finding. The language of section 98(2) is imperative and mandatory in terms. The object appears to be that on a question of fact, in the event of a difference of opinion, views expressed by the lower court needs to be given primacy and confirmed. The appellate court cannot examine the correctness of the finding of the fact and decide upon the correctness of the either view. At that time, the appellate court again refer the matter to the primary court to entertain case as a fresh. Is it?
Yes. I'll read this. Order 1, Rule 10.
Okay, read.
Suit in name of wrong plaintiff.
Okay.
Where a suit has been instituted in the name of a wrong person
Okay.
as plaintiff, or where it is doubtful whether it has been instituted in the name of a right plaintiff,
Okay.
the court may at any stage of the suit, if satisfied that the suit has been instituted through a bona fide mistake,
Okay.
and that it is necessary for the determination of the real matter in dispute, so to do, order any other person to be substituted or added as a plaintiff upon
Okay.
such terms as the court may think fit.
All right.
Court may strike. Next one is court may strike out or add parties. The court may at any stage of the proceedings, either upon or without the application of either party, or on such terms as may appear to the court to be just, order that name of any party improperly joined, whether as plaintiff or defendant, be struck out, and the name of any person who ought to have been joined, whether as plaintiff or defendant, or whose presence before the court may be necessary
Okay.
in order to enable the court effectually and completely to adjudicate upon, settle all the questions in law in suit, be added.
Okay.
Yeah, same thing is this. No person shall be added as plaintiff suing without a next friend or as a next friend of a plaintiff under the disability without his consent.
Okay.
So you can add or you delete. That provision is there.
Okay. Okay.
So
Provided the court should
people
satisfy
get
it.
confused. Yes, yes. So most of the people, they get confused between Order 1, Rule 10
Okay.
and Order 6, Rule 17. So people get confused between these two. So these
Okay.
two are two different things. Order 1, Rule 10 deals with adding and deleting of parties. Order 6, Rule 17 deals with any amendment, additional facts to be given.
Okay. I mean, added to the plaint.
Yes.
Good. Good.
So
Good.
people get confused between these two.
That is adding of the person. This is adding of the facts.
Yes.
So the appeal against a dead person. A person who has unknowingly filed an appeal against a person who was dead at the time of its presentation shall have the remedy of filing an appeal afresh against the legal heads of such deceased in compliance of the Limitation Act. Suppose if he came to know after the bar of the limitation, then the suit cannot be entertained against the representatives. Am I right?
There is a provision within 90 days, the name should change.
Means he came to know that the person to whom against he filed a case is no more, then he can change the plaint and make the representatives of the deceased in the plaint. Is it not?
Yes, but that has to be done within 90 days.
That's why they say deceased in compliance of the Limitation Act.
Yes.
So, forms of appeal. Appeal may be broadly classified into two kinds. Number one, first appeal. Number two, second appeal. The subcategory under the appeals are appeal from the original decree, appeal from the order, appeal from the appellate decree or second appeal or to a high court, or the appeal to the Supreme Court. Form of appeal. It is the amount or value of the subject matter of the suit which determines the forum in which the suit is to be filed. Here forum means court. Am I right?
Good. Yes, yes.
And the forum of appeal. The first appeal lies to the district court. If the value of the subject matter of the suit is below 2 lakhs, 1, 10, 100, 1000, 10,000, 2 lakhs here. And to the high court in all other cases. Means it's a pecuniary jurisdiction.
Yes, High Court and Supreme Court has unlimited jurisdictions.
Okay.
But other courts, all subordinate courts, they have
Limitations.
pecuniary jurisdictions. Yes.
Okay. That's why they
All
say.
subject, that's why they call three matters now. Three jurisdiction. One is territorial jurisdiction, subject matter jurisdiction, and pecuniary jurisdiction.
Yes.
All subordinate courts have these three jurisdiction, except the High Court and the Supreme Court. They don't have any. They have unlimited jurisdiction.
Very nice. Very nice. Appeals from the appellate decree, Section 100, Order 42. As per the Section 100 of the Civil Procedure Code 1998, an appeal shall lie to the High Court for the decision made by the District Court. An appeal lies if decree is passed ex parte. If a High Court is satisfied that substantial question of law is involved in, it shall formulate the decisions. It is to be noted that second appeal is on the grounds of the substantial question of law, not on the finding error of the facts. So second appeal cannot be made on the finding error of the facts. The second appeal is grounded on substantially the question of law.
Law.
Nature and scope. What about the tribunals? If a tribunal has given the award,
Mhm.
can we go for the respective tribunal, state high court? Our tribunal
No,
is equivalent to
whenever
the high court.
no, tribunal is not equal to it. Once you go to one tribunal, you have an appellate tribunal.
Okay, 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 okay. In that track, we have to go. Right.
Not to the high court.
Because there is appellate
Yeah,
tribunal.
you have to
Yeah.
go in the same track.
Okay, okay.
Once you go to the appellate tribunal, then in that whichever tribunal you are going, it will be written there. The next appeal can be to the High Court or Supreme Court.
Depending upon the
Yes,
rules of practice.
yes, yes. If you look into this IBC, Insolvency Banking Code,
Okay,
uh, first it will be the NCLT, National Company Law Tribunal.
okay,
Then from there you have to go to NCLAT, National Appellant Law Tribunal.
okay.
From there you have to go to Supreme Court. No High
No,
Court
no
before.
high court.
No High Court.
Okay, okay. That is the hierarchy.
That is hierarchy.
Okay. Now, nature and scope. Nature of the second appeal. The right to appeal is not inherited but is created by statute. The right is a file. The right to file a suit is inherent in nature. The right to start from the date of filing suits. Then, where is gone? Nature and scope. Yeah, here. The right to start from the date of filing suits. The decision of the appellate court is final. The right cannot be declared void unless the declared by the statute. And the next point is scope of the second appeal. The second appeal can be exercised only when the case falls under these categories. A. Question of law is involved. B. Question of law should be substantial. In the two cases, second appeal can be made. Other justification defined as under section 100 of the CPC. The other justifications are concerned. Question of fact wrongly determined should not be criteria for the second appeal. So, it is clearly that the question of law is involved or substantial thing is there, or as it is defined in the section 100 of the CPC only, the second appeal would be allowed. But the second appeal will not be determined on the wrong facts determined over there. Case laws. In the case of Dudnath Pandey versus Suresh Chandra Bhattasali, it was held that the High Court cannot set aside the finding of facts by the first appellate court. I repeat, it was held that the High Court cannot set aside the finding of facts by the first appellate court. Means in the first appellate court finding fact is there, it seems. Is it?
Hmm.
In the case of the Danyanoba Bahurao versus Maruti Bahurao Marnor, it was held that finding of fact is against the weight of the evidence and there is no question of law in this. So finding fact is different, question of law is different. But in certain
It says that
cases, yes.
under Article 120 of the Limitation Act 1963,
Mm-hmm.
the period of limitation to have a legal representative of the deceased respondent
Okay.
made a party to an appeal under the Code of Civil Procedure is 90 days
Okay.
from the date of the death of the respondent.
Okay. Okay. If it is not there, then limitation bar is there.
Yeah, limitation is there. If not, people after 1 year or after 10 years, they'll come.
Yeah. Now let us see the substantial question of law. What is the substantial question of law? The term substantial question of law has not been defined anywhere under CPC, but was the first time interpreted by the Supreme Court in the case of Sri Chunni Lal Mehta and Sons Limited versus Century Springs and Manufacturing Company Limited. The proper test in the case of determining the substantial question of law differs from our opinion and opinion of the court, or in our opinion, it is a general public importance, or if it affects the right of the parties, and also when decisions are not finally settled by the court or the federal body, and in the cases where the court perceives that there was involves a principle, then the principle to be applied when there is a substantial question of law. So, if the people logic will be affected, party will be affected, and general public importance would be there, and finally not settled by the court, at that instance, it involves the principle that the principle of to be applied. They say there is a substantial question of law is there. The question of law to be substantial, it should be questionable. It will also depend upon the facts and circumstances of the case. So, it depends on the fact, circumstance of the case, whether it is a substantial law or not. Like we discussed earlier, it is a matter of reasonableness and substantialness, generalness.
Why your screen is not changing? I can see the same screen from last 20 minutes.
No. See, the same thing is there. Still, I am reading the same.
Okay.
So, in the case of the Mahindra and Mahindra Law Limited versus Union of India, it was held that case should involve the question of law, not merely question of law. So, they say not merely a question of law, but really involves the question of law.
Yes.
So, the court record the reason for the substantial question of law. So, the question of law is involve the question of law, not merely a question of law. So, in the case of MS V. Raja versus Sini Tewar, it was held by the Supreme Court that formulation of the substantial question of law may be inferred from the kind of questions actually considered and decided by the court in the second appeal. Of course, we read it. Second appeal comes at that instance only when there is a substantial law is there, involved over there. Even though the substantial question of law is not specifically and separately formulated. So it is inferred from the substantial question of law from the kind of the questions actually considered. So question of the law of general importance. The question of law of general importance goes in this way. The second appeal can only be filed when there involves a question of law and the question of law should be substantial. If it is of general public importance, it affects the right of the party substantially. Section 100 of the CPC also deals with the importance of the question of law. So, if a case falls under the section 100 of this, then we can say it's the importance of the question of law. If the general public also affected over there, then we can say it is the right of party substantially. Question of law comes over there. Clause 3 states the memorandum of appeal shall state that a substantial question of law is involved. So, when the substantial question of law is involved over there, then only the second appeal. If not, it is not based on the question of fact. Clause 4 states the High Court is satisfied that it involves a substantial question of law in any case, and it shall formulate the questions. No second appeal in certain cases. This is defined under section 102 of the CPC. But if any appeal falls under the section 100, then the second appeal will be allowed because they involved the substantial law. So no second appeal shall lie when it is cognizable nature by the court of small issues. Yes, no second appeal for the different cases. No second appeal shall lie when there is the finding of the error in the jurisdiction. Yes, if there is any finding of the errors in the jurisdiction will be there is no second appeal lies. And the no letter patent appeal. What is this no letters patent appeal? Any idea?
Yeah, there is something called latent appeal and patent appeal.
Okay. So letter of patent appeal is an appeal against the decision of the single judge in the same court. This saves the petitioner from going to the Supreme Court, saving a lot of cost. So latent patent appeal is appeal against the decision of the single judge in the same court. In this, the petitioner has the option to move the case to another bench where there is more than one judge. So if the single judge is given over there, we need not to go to the Supreme Court. We can go to a division bench or a double bench. Is it not?
Yeah.
But only the thing is, it should be more than one judge.
Division bench.
Can a party is having a right to change the bench because he feels that the bench will not favor me because the bench clerk or somebody will be attached with the second party?
That you have to prove it. You have to inform the court.
Yeah, we can say that the judge is wife's brother case it is.
Yes. Then no. Normally, what happens is that the judge themselves they'll rescue from that matter.
Means he will not entertain. Please settle. Please keep this matter in the another bench because they are related to me.
They are related or the known, or he might have met him. Some parties frequently must meeting him. So it happens most of the times.
Means there is a probability that people will think that he is collaborated with the other.
Yes.
So at that instance,
or if the complainant or the respondent feels that this judge is not favoring me, always he's favoring only the plaintiff, then he can make an application. Then the judge also will say, okay, you take this matter to some other bench. Let him handle it.
can they appeal to the Chief Justice of High Court if matter is in the High Court bench?
No, you have to make an application to the same bench.
That's the same bench. Okay.
Same bench where the matter is. You argue your matter. Then the judge himself will say, okay, he'll forward that file to the registrar to file it before another bench.
Okay. But sometimes no, even the advocate will not say, oh, that bench. No. Let us wait. Because the judge never give the against the government.
क्या होता है कभी-कभी क्या रहता है ऐसा people think, but it is not always like that.
Okay.
Because if you can't argue well, you can't blame the judge for that.
Okay. It is nothing but a unwise man always quarrels with the tools.
Yeah, you always be sharp with your tools. If you're not sharp with your tools, how can you blame the other person for your laziness?
That is why we'll say in Hindi or Urdu, नाचना न्याय के अंगन टेढ़ा.
नाचना आया आंगन टेढ़ा.
नाचना आया ना आया अंगन टेढ़ा. First, he doesn't know how to dance and say the platform is not good. It's ups and downs.
Yes.
Or F's. So, Article 226 and 227 of the Indian Constitution has provision, and judgment passed in the Article 226 states that it can be issued to any person or authority in any case, and under Article 227, it empowers the High Court to have a superintendence over the subordinate courts and tribunals. So, judgment of the Article 227 does not fall in this category. Now, let us see what other things are there. The intercourt appeal in case of the High Court is for 30 days, and it is for the 90 days in case of Supreme Court. Intercourt appeals means in the High Court from one bench to another bench. What it means here, intercourt appeals in case of High Court are from one High Court to another High Court? No.
What happens? No, it's not like that. If a single bench has given, if a single bench, a single judge of High Court, if
you can refer the matter to the
double bench
or division bench, whatever it may be, but more than single bench.
Yes.
Can you say it's appeal or can you say it's a revision?
Appeal also or revision also you can do. Revision is mostly done on law.
Okay.
Appeal is done on facts and law.
So one judge to the another, single bench to the double bench to the division bench, it is a matter would be in 30 days. But for the 90 days in the case of the Supreme Court, if he is not happy by the decision of the High Court. Letter of patent appeal is not maintainable in the Arbitration Act. Okay. So in the Arbitration Act, the letter of patent appeal is not maintainable. The
Yes.
High Court of the Bombay held that LPA is means letter of patent appeal is not maintainable under the Section 8 of Arbitration Act. Why do they say High Court of Bombay? Why do they say High Court of Maharashtra?
Good question. Earlier, there was nothing called Maharashtra. It was only Bombay Princely State.
Acha, 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 acha.
Bombay Princely State, sir. Just like Madras. They don't call Chennai. They call Madras High Court.
Yeah. Neither they call Court of Tamil Nadu.
Yes. Even still today also, it is called Bombay High Court. You call Chennai High Court. You don't call Mumbai High Court or Chennai High Court. It is Madras and Mumbai and Kolkata. Not Calcutta. Kolkata it is.
Yeah. Okay, okay, okay. So only Section 37 of the Arbitration Act would apply.
Yes.
So restoration application along with the application of the condonation is not a maintainable. Restoration application along with the application of the condonation is not maintainable. Then letter patent appeal shall not lie from the decree judgment of a single bench under Section 100 because 100 prohibits for the second appeal. Order of suit, not a judgment from one court to another, is not maintainable. Order of suit, not a judgment. But the judgment cannot be made, only order of the suit can be made. Is it? Forum of the second appeal. Appeal from the original decree. Generally, every decree passed by the subordinate court firstly appeal has lies to the High Court, but the appeal shall not lie if it has been passed by the consent of the parties under the Section 96 of the CPC. If the parties agree would be there is no question of appeal. Am I right?
Yes.
Appeal from orders. An appeal shall lie from the order which is appealable. Then it is an order made under Section 35 capital A, that is a compensatory cost, refusing to lieu to institute a suit under the nature of the Section 91 and 92. An order under Section 95, that is the compensation for obtaining the arrest or injunction. So these are all the appeal from orders. Insufficient grounds. Any order made under the rules for which an appeal is expressly allowed by rules. Insufficient ground. An order made under this code imposing a fine or directing the arrest. Appeal from the appellate decree. An appeal shall lie to the High Court if decree passed by the appellate court. Okay. If the judgment is ex parte, it involves a substantial question of law, then we can go to appeal for the High Court. The substantial question of law has to be formulated, otherwise appeal would be dismissed. Yeah, it should be shown over there, otherwise appeal will not be maintainable or dismissed. Appeal to the Supreme Court. An appeal shall lie to the Supreme Court if the case involves a substantial question of law which is of a general importance. When the High Court thinks of themselves, the case is deemed to fit and decided by the Supreme Court. That is called leave petition, is it not? Grounds of appeal. Appellant has to mention the grounds of appeal in the memorandum of appeal. Appellant has to mention the grounds of objection and present it before the appellate court. The new ground can be raised by the additional application later on, and the High Court has the power to reject or accept the application if the new grounds are there. Power of High Court to decide the issue of fact. This is defined under the Section 103. The High Court can decide the issue of the fact if sufficient evidence is found and the court thinks is necessary for the disposal of the appeal. It is self-explanatory. If it has not been decided by the lower appellate court or both by the court सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।